I will,
Definitely for me.
all right, good morning, everyone. We'll probably just get started, give everyone a little chance to get in. First off, thanks in advance, everyone, for your attention. Thanks to everyone who was able to take a second, take a look at, or even fill out the survey I sent out yesterday. As usual, I had a lot of fun, probably too much fun, learning about this topic and putting these slides together. And I ended up covering a lot in this talk. So I try to keep it all germane, and I know there's probably something in most of these slides for everyone at all levels. So without further ado, order on the court: protections and privilege versus risk and liabilities. All right. This is how we're going to break it down here. We'll start with just some formal definitions, kind of the physicians in focus, and then we'll talk about the threats and protections that these physicians have, and then we'll discuss some of the challenges to our integrity, as well as kind of the real world legal hurdles that we jump through in the sports world. And then finally, we'll round it out with some context for the hottest topic in college and high school athletics right now, before we give our closing statements. So what is sports medicine? What does it mean to be like a team physician? I think on the surface, it can be glamorous in some settings, in some ways. So it's really easy to kind of just be a fan without knowing the full story. So some of the things that make sports unique, or at least being unique about being a sports surgeon, is that your practice has a ton of variety. So you kind of get to deliver, and that's in location. So you have care delivery in multiple different types of locations, and that of course affects the types of treatments that you can do in these areas. And there's also variety in kind of where in the body you give your expertise, and with that comes a wide range of pathology that we end up treating, and ultimately a lot that you can do surgically for your patients. But probably the most unique part about sports is our patient population. So you kind of treat young and old and athletes along the entire spectrum, from weekend warriors to the most elite team athletes, and those guys and the physicians who take care of them are sort of the focus of our talk. So a few years ago, the AAOS came out with this consensus statement on what makes a team physician, and they kind of talk about some of the key requirements and desirables that put you in the category of team physician. Their only formal outlined criteria or qualification was a medical license. They talk about some of the medical duties in terms of on game day and in the training room, and then they spent a lot of time actually talking about that. That document spent a lot of time actually talking about the administrative duties, like coordinating all the other providers on the team, and your role with discussing things with the other stakeholders in the athlete's care, and how involved the team physician should be in event of emergency preparedness. So kind of these roles all end up overlapping, and when you put them all together in one person, you kind of get what is the team physician. But that's just words. So I thought I'd kind of give us a little imagery to help things stick here. So first up is Ryan. I asked him to send me a photo, but we'll use one that I had of him. So he spent, budding sports surgeon. He spent some time on the sideline. Maybe he makes the USS team doc. Maybe he makes the boat. Unfortunately, he actually doesn't pass the first criteria, since he nor any of the PGY4 class have actually gotten their medical licenses done. He's gonna miss the ship. Next is Dr. Swan. Seems pretty straightforward, right? Has a ton of sports knowledge, makes decisions on the sideline, coordinates all the athletic trainers and event preparedness. So easy add. But then there's Dr. Monica. So he's a hand surgeon, not a sports surgeon, right? But I think don't let that fool you, right? He spends a fair amount of time on the sidelines, traveling with the team, with the sports teams, making game day decisions about their injuries, and educating athletes and families. So we'll keep him on the USS team doc here. And so why would you, I said some of the things that make sports unique, but why would you take on kind of those additional burdens that the AAOS highlights for you? Well, for me, I found, or I came to ortho because, I wanted to be a part of a high impact specialty. And I think team physicians make some really high impact decisions about treatments, like, choosing to end Jomar and really the Grizzlies' entire season due to his shoulder instability, or managing Bronny James' kind of return to play after his cardiac arrest, or letting Kobe stay out on his torn Achilles to push through, get his free throws in, and push the Lakers through to the playoffs that season. They actually end up losing the very next game in the playoffs. But and then of course, right, there's the surgery, right? So I think being involved with the care of some of the biggest names in the sport is another plus for some surgeons, right? You get to bring your surgical expertise to the Tom Brady's and the Tiger Woods of the world, and at the professional level. You kind of get a front row seat to see some kind of really interesting stories, see how the other half lives. Like, Tyreek Hill going from being arrested, an hour before the game to being arrested in the end zone all before halftime, which I still think is like insane. I don't know how that happened, but honestly, probably the final reason, a lot of times, like, you're having a good time, you're enjoying yourself. Jeremy and I, we matched outfits and we did opposite hairstyles here. Here's Bobby Chabra, enjoying the win with UVA's when they won the NCAA tourney. This was actually a few months after doing surgery on one of the players' scaphoid. So, it's really, really a powerful moment for him. And, when Rutgers wins, we're all having a good time. It's a blast. But there's no free lunch in ortho. We've heard that all before. And so it's all fun and games till someone gets hurt, and someone's bound to ruin a good thing, and it can be really huge and an expensive problem when that happens. And I won't go into too much of the details here, but for those who don't know, Chris Maragos was safety on the Eagles who had surgery for a knee injury, and that turned out to be a career ender for him. And he claimed that mistakes made in surgery and in his rehab kind of led to his failure to return to play, and the jury took his side to the tunes of tens of millions of dollars. And so some people say, that, well, this is an outlier, but if you do a little digging, you'll find that one, the numbers on some of these cases are dizzying, and two, Maragos is not alone by a long shot. And so, one article I read said that the number of multi-million-dollar suits are on the rise, and the number of verdicts in favor of plaintiffs in these kinds of cases are as well. And so, you look at USS Team Doc right now, and they seem to be taking on water pretty fast here. And at first, the USS Team Doc seemed like a great place. A few slides ago, we were having a good time, but really, probably more like USS Liability at this point. And now the risk is really getting to an intolerable state for many of even the biggest names in the field. And to Jeremy's dismay, the Eagles have Rothman is no longer taking care of the Eagles. I mean, the response has just been to cut ties in some cases. And after that famous ruling, right, the AOSSM, or the sports governing body, released their statement on how the current landscape, the current state of affairs is becoming far too hostile, and called for protections for physicians. So more didn't choose to cut ties, as we saw with Rothman. And not everyone's going that way. Some physicians are doing the complete opposite, and going on the offensive. Dr. Franklin, the former Penn State doc, sued and actually won, because he felt that he was being pushed to do things that were medically risky, and was removed because he wouldn't comply with those requests. So I mean, it's really a tumultuous time in the sports world for us. But our friends in the USS Team Doc, or USS Liability, they're not alone out there in the sea of sports issues. Like all doctors, they carry one of the most important insurances we have, pocket protection. And so this was one of the first questions that we talked about that in our pre-quiz, right? So which of the following best describes the legal definition of standard of care? Most of us, we did pretty well. Most of us chose option 5 here. And unfortunately, this is the correct answer. I wanted to just kind of point out that this was actually a verbatim question from the AAOS self-assessment test. So it's not just from, ortho bullets. It's actually something that our academy wants us to know. And so I figured, since our academy wants us to kind of be in tune or abreast with the knowledge on malpractice and malpractice insurance, I figured we'd go over a few definitions here. So what is malpractice? So malpractice is kind of the four, there are four parts to it, or legally, there are four tenets that must be met before you can say, something can count as malpractice. And the way, as kind of putting this, a lot of people refer to it as the 4Ds. So the first two are duty, and some people call it breach of duty or dereliction. So that means that, you truly had some relationship with a patient. That means, you're actually responsible for their medical care. So when the ER calls and says, oh, it's not a consult, but then a few hours later, your name and department and all your decision making and your phone number are all in the chart, that's an attempt at established duty, and add liability to you there. So that's duty. And then breach of duty means that you did something that was not the standard of care. So wasn't that fourth answer choice. And then not only do you have to have duty and breach of duty, whatever you did or said to do has to, there has to be causation. So whatever you did had to have some proximal relationship or be linked to the issue at hand. And then finally, you actually had to hurt the patient or actually had to do something. And so, I think of this kind of like the no harm, no foul clause. But the trick with damages and injuries, it's not just physical, right? That, more and more people are suing for economic damages or emotional damages, like time out of work or, emotional distress because of unnecessary surgery. So you really have to be careful there. You can kind of get caught up there. And then probably our next thing that we asked was, so what does malpractice insurance do for you, right? Which is kind of what we're hoping to capture here. What we go over the cap, now what? And most of people said that, once you're over the limit, you're high and dry, it's on you. So we can go through and kind of see if that's true. So what is malpractice insurance? And, you kind of do a little reading into it, and you kind of get into this whole, things get kind of out of hand really quickly. But I tried to separate things out a little. And basically what it comes down to is, there are a few things to remember. One, there are two main types of insurance, claims made, which covers you if you have a policy at the time a claim is made, no matter when the actual malpractice occurred. And then there's occurrence-based, which covers you no matter when the claim is made, but when based on when the actual malpractice occurred. So it's kind of in the name. The caveat being that claims made policies have to have a tail, which will cover any claims that are filed outside of your policy coverage period, for example. And so then, of course, you have the premiums. They're your monthly or annual costs to insure and are dependent on things like your state, your time in practice, your claims history, and the amount of coverage that you're getting, your policy limit. And of course, your policy limits is really usually it's quoted as the amount of coverage per occurrence, and then kind of a cap for the total, the entire policy period. So, and then lastly, there are kind of these, hodgepodge of clauses that determine, how your company behaves during a lawsuit. So whether, you control if they settle or whether they can settle without your input, how much the defense will cost if you're responsible in the case of a win or a loss. And a few other things, but kind of one of the things actually I thought was really interesting to dive into was this idea of social inflation, which I encountered when I was kind of learning about the kind of the insurance world. And so it's sort of this is a graphic from the amtrustfinancial.com. I thought it was like a really interesting graphic. You maybe check it out if you're interested. But essentially, social inflation is sort of the phenomenon that economists are using to explain why the cost of lawsuits are kind of ballooning up to the kind of these astronomical levels that we see kind of marching far beyond or much quicker than you'd expect due to just economic inflation alone. And so, the claim is that, every time a jury awards a $50 million check to a plaintiff and social media gets a hold of it and publicizes it, it gets easier and it almost becomes expected to give awards of that size and greater. And so this infographic kind of talks a lot about some of the things that, highlighted some of the things that affect doctors specifically, like, erosion of caps for pain and suffering, and the impact of kind of public opinion and changing definitions of liability, which we'll kind of get into a little bit later down the road in this talk. And then kind of the bottom line is that, social inflation is kind of ballooning jury verdicts, kind of well beyond our typical insurance coverages and policy limits. So it makes us as doctors appear like a much more risky group of people, and that starts to push our insurance rates and our premiums up. So that's why we care, because it costs us money. So you're right. It is the physician or the physician's estate. So I don't know how many of you have $9 million just laying around to cover over top of your insurance. So backup protection, extra legal defense is going to become something that you're going to have to be savvy with if you're unfortunate enough for someone to put kind of one of these astronomical lawsuits against you. So here I'll sort of change gears, and I'll talk about kind of some of the ethical challenges for team physicians. I think by and large, most of us, in medicine have kind of like good to excellent moral compasses, but I think as team physicians, we face some really serious challenges, as everyone does, but to our professional identity and integrity, and some of the kind of the artificial, kind of these artificially intense scenarios that you can encounter. So probably the first question that you have to answer is, who are all the stakeholders, right? I think we have some of the usual suspects, of course, but also there are, others who are exerting pressure on this kind of physician-patient relationship in really unique ways. And I thought that, again, to stay topical, we'll kind of look at, the man under center who's kind of been in the news lately. It's kind of funny that we talked about him yesterday briefly. So this is Tua Tagovailoa. He's a former Alabama standout. A lot of us know him, but he signed a 4-year he's a top passer last season in the NFL, which is probably why he ended up on Ryan's fantasy team. He's probably pretty sad about that now. He signed a $4 million, a 4-year, $200+ million deal in July, and now he's a concussion 2 games into the season, putting him on the injury reserve. Kind of the dilemma here that an expensive athlete gets injured, but kind of the dilemma here is that Tua is hurt, and his leave from the NFL, at least it's been speculated that it's imminent. So the manner in which he leaves is going to determine will be at least a $120 million swing. So even though so if he leaves because of a medical decision, he'll get $160 million in guaranteed, but if he is cleared and decides to retire to protect his head, which maybe a smart choice, he'll at most get $40 million. And in fact, the Dolphins may be able to prorate a lot of what they've already given him and kind of leave him with a lot less. So even though the first and the strongest relationship here, right, is between the team physician and the athlete, right? Many others exist that are going to, kind of cast doubt on decision making because of, other incentives or goals, and kind of your professional integrity urges you to do the right thing, but your practice is depending on the relationship with this team, kind of to bring in patients. So you struggle to make a decision that's going to, that the organization may frown upon, right? Every news outlet is casting, is calling for the team doctor needs to make the decision. And either direction you go is going to, bring backlash from tens of thousands of people. And of course, the other players are there, right? And they're important too, because no one trusts a doctor who's, putting a player out in the line of fire who's hurt to get hurt again. But also, some of the teammates want their franchise QB back. In fact, that's why a lot of people follow this team and came to this team. And so kind of many of these same individuals are also leaning on our athlete and kind of pressuring them overtly and inadvertently. And kind of at some point, the noise becomes too loud and kind of erodes that doctor-patient relationship, and kind of decisions get made without the help of the patient first. And sometimes people get hurt in cases like these. And so that's just one case, and kind of a recent example. And of course, we can go into and discuss some of the the details of it. But I thought I'd also spend some time kind of talking about one of the other common challenges that physicians face, which is with confidentiality. And I think probably the first grounding question to ask yourself or to answer is, what is the privacy rule? What does HIPAA say? And in short, it talks about covered entities, so physicians and health insurance companies, and talks about the fact that they must obtain consent to use or disclose protected health information. So that's what the privacy rule. So that means, unless a patient has given, some express consent, then a physician can't share PHI with anyone on the street, or even covered entities, unless, it's required for patient care or for billing. So, so what about, Dr. Gass here in the room, I'm sure, head coach Sass, what does the MRI say? And, what do you do then? Or if you're a pro team, right, you have a talk with an athlete or your patient, and they disclose something to you, what do the rules say about disclosing that to the coaches and team staff? So I think it actually comes down to whether or not you're employed by the team. And so if you kind of spend too much time looking through the HIPAA 1996 rules, you'll find the answer. And in fact, there was probably an easier way, which I found first, was a study in 2013 by a group based out of Duke, kind of said that, or put it very eloquently, if you're hired by a team to care for an athlete, you're not bound by the HIPAA privacy rule. And that's because the athlete is essentially telling an extension of their employer. So when you're employed by the team, you're a part of the enterprise. So anything that the athlete tells you is a part of the employment record. And so that's not covered under HIPAA. And so that's why that information can be shared without breaking any laws. College is a little trickier. But in short, the kind of the information obtained, like when an athlete is seen in the student health center, for example, that's covered by FERPA regulation, and that should be safe to share between coaches and trainer. And then people even doubt, if you go down this whole, people dialed in even deeper. Well, what about on the field? You're not in the office. You're not if you're a college team doctor on the field, what do you do then? Because you're not in the student health center. It's not covered by FERPA. And some people have stipulated that, well, in those cases, they're emergency evaluations, and kind of some of the pre-authorization is technically not needed to share information, but it does get tricky. The legal landscape can get a little bit gray in some areas. So sometimes you kind of feel like, this in this ethical world of being a team physician, kind of you have all these things I spoke about, and then many more, right, that I wasn't able to I didn't cover, that are trying to pull you away from center. But at the end of the day, if the best you can do is know and follow the law and put your patient first, and do things for the patient, that certainly won't. That people who have done that certainly have faced suits, but that's probably the best you can do, at least to sleep at night. So, and the next thing I wanted to cover, moving away from some of the ethics, I was talking about some of the the legal challenges that you can have when you're in an away territory or for away games. So one of kind of this age-old question, maybe not for everyone, but it seemed like it was a big question. Is when a team travels and the team physician travels with them, are you masquerading around as a doctor, and you're really just just another guy? And that's what this question that I posed wanted to test here. So which of the following best describes the laws regarding team physicians? And we had a wide array of feelings from everyone. I think most of the people either said it was legal, depending on, or looks like it said, it was legal depending on where you were delivering care, or it depended on the state, whether or not it was legal. And then there was kind of a smattering of everything in between, and no one thought it was illegal to provide formal medical care. So that's not bad. Let's see what happens. So if you do a little digging, kind of before 2014, a decade ago, when Rutgers first entered the Big Ten, Viola et al. in their study asked a question across all the states. Is a traveling team physician a physician in your state if they travel? And so she found that it was totally state dependent, and really not uniform across the states that had rules. So 16 states had rules that said okay, a traveling physician can be a physician in our state and practice medicine legally. 2 just had no policy, neither for or against. 6 of the states said they could be supervised by another physician, and then the remainder really just expressly prohibited it. And then sort of to give this a little context, so highlighted here the states with schools that were in the Big Ten in 2014. So if you're traveling then, it was actually, mostly illegal for you to provide formal medical attention to your players, including in New Jersey. So what'd you do then? So, a lot of physicians, look to the Good Samaritan rule as sort of this loophole to say, well, I'm providing care for someone who needs it, and I should be not culpable. And so kind of that's the main point of the Good Samaritan rule, right? It's like, it's to absolve people of kind of this potential liability in order to encourage people to provide emergency care for people in distress. And so the laws vary from state to state. So, looking up New Jersey's laws, they pretty much go by that premise. And the challenge for the team physician is that most of these laws actually include specific text that would exclude, a team physician, right? So it says, anyone whose duties require a response to an emergency, that is, i.e., you have to truly be a bystander for the Good Samaritan laws to apply to you. So you can't be like getting paid, wearing the team gear, eating the team food, providing non-emergency care, and then count as a Good Samaritan. But so kind of puts you in a sticky situation. But fortunately, some changes came down the pike, and the AOSSM actually published this release in October of 2018 when the Sports Medicine Licensure Clarity Act was passed. And the bill sort of details a few important things, namely that it is legal to practice outside of your home state and in the capacity of a traveling team physician, and your liability insurance has to cover you. So it gets rid of the odds and ends laws from, all the years past and makes a federal stance as a federal law that tells, exactly what it is you are able to do and that you're covered. And moreover, it also specifies some of the things, right? So where you can practice. Or I guess better yet, it sort of confines your practice. So it keeps you out of hospitals out of your state. So you have to, you can only practice medicine legally, technically, in areas of competition, like the training room or on the field. So that means that's just the covered medical areas. So that means the answer to this question here is choice one, right? So it's legal to practice in specific locations now as of that 2018 ruling, and we won't speak of anything that happened before then. And then probably another. So now you have medicine. Now you can practice. You're a doctor. You need medicine, and so this is a tough question. Maybe I asked it funny, but I used Adderall, as I just mentioned it, and it seemed kind of innocuous, but it's actually a Schedule II drug, right up there with OxyContin and other narcotics and other opioids, and the majority in this case voted that as long as you document things, you're safe to carry controlled substances across state lines, and the other said depends on the state of licensure, and I think those are safe option. And someone said, it's legal to possess, any quantity of these medications. So, the Controlled Substances Act was passed in 1970, and it talks about, some actually very strong verbiage about trafficking and possession and distribution and essentially like moving weight across the country. And Dr. Kading out of Ohio State actually did a very good job kind of summarizing I thought it was, this points are rated, summarizing DA's thoughts on kind of interstate passage with controlled drugs, and you can't do it, period. So shocking, but true. So you cannot, leave one state with a drug that's not prescribed to you and go to and take it to another location in another state. That's not like a farm. You can't, if you're traveling from pharmacy to pharmacy and that's your goal is to bring it from one place to another pharmacy, you technically can do that, but short of that, not okay. And so how are you going to practice medicine without medicine, right? So Dr. Kading in his paper also kind of gave some really interesting ideas. One, like phone a friend, right? Making arrangements with the home team to have them have some controlled substances on standby that if you should need them, for your team, right? That sounds like a logistical nightmare. And if you've been to an away game with like, the college level, it sounds insane. I mean, I think of just, all the away teams that come to talk to us. It's, we first met them that day. So that sounds challenging. He also talks about, maybe calling pharmacy, and calling ahead to a local pharmacy to have them sort of, to, and again, I wish I highlighted it, but it almost sounds sarcastic, to be prepared for you to prescribe and pick up an unknown quantity of unknown meds past business hours on a it's a nightmare field if you're the team physician to kind of to logistically handle that. So no one actually got this one, right? So you actually can't do that. So this one, I know everyone who took the survey learned at least this slide today. Hard no, but there's hope on the horizon. So this the WAS is supporting this bill that was introduced in 2021. House Republicans Pete Sessions that would allow physicians to transport controlled substances in limited quantities for predetermined periods of time. This bill actually, a previous version of this bill, if you kind of dig down again, died in 2018. It was introduced first in 2017. I think died on the floor. Is it right? I think that's what you say. But we're hoping for a better outcome this go around, and hopefully this can help to kind of clarify some of the muddier waters for team physicians who are traveling out of state. So next slide. Yeah. So safety and amateurism, right? Kind of before we go, so I'm going to go into kind of the last segment and talk about the NCAA and NIL. There, I said it. But I wanted to kind of clutch on this idea of amateurism, right? Covering local games with high schools, or even mid-major colleges, not traveling out of state, right? It's a much more safe, legal and ethical environment, right? The patients come with fewer external pressures and have relatively normal expectations, or expectations that you can at least manage, right? There are fewer people around to kind of cater to, and there's less speculation on how good this person could have been if they had continued their sport, and they're amateurs, so like they do this for fun, right? So this isn't a job for them. They're having fun. They're kids playing. So maybe the amateurism covering these games are kind of the warm flame in a dark cave for you, so to speak. But I digress. All right, so coming up on the final bend here, does anyone know who this is? Yeah, exactly. Right. So, and why is this game important? Or actually 2010, I think was the last one they made. Yeah, that's it. Exactly. Right. So thanks for staying with me. So I'm going to talk about kind of before I get into NCAA basketball and all this stuff, I'll add a personal touch with some anecdotes here about the control that the NCAA had. Hey, who's that? So when I started on the track team at William and Mary, we had to do hours and hours and hours of compliance meetings and paperwork, which was actually, I was 17 when I got to college, so it was actually really frustrating because I had to send everything to my dad and he had to sign it and send it back. But two things I remember very specifically that stick out to me was one, before in the 2 years when I moved to the States before college, in the summers I coached at a children's track camp just to keep busy at the high school that I went to. And when I asked them in the compliance, it was like, they talked about jobs and all the regulations. I said, oh, okay, I don't know what I'll do this next summer. That's a long time ago. I'm 17. I don't know what I'm eating tomorrow, but maybe I'll do that again. And they said, yeah, you can do that, but the camp can't put your face on any posters, and they can't write your name on any poster. They can't say that a Division I athlete is coaching the kids. Basically they can't advertise that they have someone in the NCAA at their camp. which at the time I said, oh yeah, I guess that makes sense. But I said, yeah, that makes sense. But in hindsight, now with kind of the clarity you have, we realize that that was really them kind of controlling kind of your image, right? My name and likeness and image rights, at the time, and that's me at the coaching at the camp there.
Were they even trying to advertise that though? Like if I wasn't there.
Yeah, I was like their Jamaican star, anyway. Um, but you couldn't do it. And I mean, they were really, aggressive about it. And then the other thing that I remember very, very, acutely was Chipotle Gate. So as a student athlete, this was just at William Mary, it wasn't everywhere. But as a student athlete, you weren't allowed any extra benefits, right? So, you couldn't, if every member of the student body couldn't have this thing at that time, then you weren't allowed to have it. That's, that was an extra benefit. And so there was actually a night Chipotle had just recently opened in Williamsburg, really progressed. 2012 was the first Chipotle there. They had nights for kind of different student interest groups, right? So they had a Greek night, there's a freshman night, and all these nights there were different discounts that you could get. And then they had a student athlete night. And word got back to compliance. And everyone who went, because they identify everyone, so they say, oh, you're a student athlete, and they identify everyone. Everyone who went and was identified had to pay back whatever discount, like it's immune compliance, pay like whatever $6 or whatever for a burrito, because it was considered an extra benefit. So it was, I mean, like, it's just a burrito. But really, and in my head, I was like, yeah, I mean, guys, like, you shouldn't do that. That's something extra. You can't get that. But now, kind of keep that in mind as we think about the context of what's going on. So now, knowing what's happened, I asked this question, right? So is Jomar eligible to receive his share of a $3 billion lawsuit against the NCAA? Did you know that the NCAA has a $3 billion lawsuit in the works? So for whoever said no, I'm going to take my cash. I'll share with everyone else. But we'll see. We'll pend on see if that check comes through. But anyway, back to the game. So, yeah, Chernoff on the cover, but Ed O'Bannon, right? So he was the 8th overall draft pick in '95. And you're like, okay, 95 but 09. What's the link here? But more importantly, he was the MVP in the 1995 UCLA NCAA tourney championship. And that was actually last time, in the kind of wooden era where they won the NCAA championships. And so what does that have to do with NCAA, hoops, college hoops 09? They actually had a legacy team of the 95 Bruins team, and he was on it, and he saw him. And just a little more context, Ed O'Bannon's time in the NBA was very short-lived. He was injured. He never became the star that he was projected to be, unfortunately. But he saw himself in this game and said, huh, it didn't have his name on the jersey, but it had, his likeness, his left, there's articles where his left-hand shot, all the things that, made like, this was Ed O'Bannon, like this was that guy. And, he said, he never received any compensation for it. And, I think this is just one where, like, it's one thing to control like the current athletes, but then the NCAA, I think, made this kind of costly error, and we'll see that it, I already talked about a $3 billion lawsuit, but kind of what ensued, I think, kind of has been this constant barrage that, we can just call like kind of erosion of control that the NCAA had on college athletes. So first, something small in the back in the 50s, the NCAA untethers athletic scholarship and academic. So that was the first time that they said, we're just gonna have you come to school and pay you to be an athlete, quote unquote. And that's kind of the first, small chink in the armor. No one thought much of it. Everyone's probably really happy with it, actually. This was the NCAA doing that voluntarily. In the 80s, there were issues with television rights. So the NCAA controlled all of the rights for NCAA sports, and they restricted the member institutions from actually bartering for their own rights. And when a few of the larger schools, University of Oklahoma being one of them, tried to do that, They said they would sanction them and remove them from the NCAA. Ultimately, they took them to court and said that it violated antitrust laws. That you really couldn't take all the money for yourself, right? The schools are there, they're participating, they're keeping the students educated. They're the vehicle through which the NCAA operates. So that was the first time that they had to share in the wealth, and it was with institutions. And then of course, I talk a lot about Ed O'Bannon and his legal suit. So in 2009, that's when he made his suit, and this was kind of it all leads back to Ed. It's kind of the first real time that the athletes themselves tried to regain control over their personal brand. And so O'Bannon thought, so the premise of his suit was that, well, yeah, maybe in college you can control, but I'm graduated, I'm not an amateur anymore. You can't keep my likeness to yourself, not without compensating me. And ultimately, that case went on for years and years and years until 2015. In 2014, the first time that Northwestern football students tried to say, well, we're actually employees, we work here. The stuff that we do should count as a job. It didn't actually pass. Within an interim, O'Bannon, the case was decided in favor of Ed O'Bannon, and that was the first big splash. And then California passes their Fair Play to Play Act in 2019, and this was the first. Essentially, it was the NIL. The first NIL rule, the first state that said you can't limit a student athlete's ability to earn based on their name, image, and likeness. And they blocked institutions from doing that. And then the floodgates opened, right? By the end of the next year, more than half of states had NIL rules. And then I think the birth of the NIL collective is probably the really the point of another. There are tons of points of no return. It's probably one of the real big ones where an NIL collective is of course a group of boosters that put money into a pot to offer NIL deals to athletes, which thinking back to when I was in college or had just graduated, I couldn't even actually go out and pay for drinks or food for my friends who were still on the team because I was an alumni and so I was a booster and I would risk their eligibility doing that. And it was great because then I could say, yeah, sorry, man, I can't cover this one. But now you can do it, and not only can you do it, it's being done on an enormous scale. And then this was to follow Northwestern's attempt. And talking about extra benefits, this was a suit by another former student athlete, Alston, where he took on the NCAA and won. And it's essentially said that student athletes should get fringe benefits. They should be able to get educational compensation for their work, and the Supreme Court agreed with them. They went all the way up to the Supreme Court, and they agreed. Books, computers, internships, and this. There wasn't a landmark. I think I've used my quote on saying landmark, but this case was the one that I talked about with the $3 million settlement. So this one is huge. It hasn't fully been ultimately been decided, but the NCAA decided here to settle for $3 billion. So I can't imagine how much they stood to actually lose. And the $3 billion comes in lost wages for athletes that were wrong. So if you are someone who competed, these are all student athletes who competed before 2021, and they said, I see you made it so people can get paid for play. I think I should have had a cut for that. And they were suing, and the NCAA settles. So again, this may have been something that could have put them belly up if they didn't. And then the last thing, the most recent suit, right? So I call it workers' comp, but the Trey Johnson and similar students took on the NCAA, and I think this is probably the nail in the coffin to amateurism in college, right? I mean, it's not closed, but again, in this case, they're arguing that they are employees of the school, right? That they deserve wages. At least minimum wage, and they should get overtime pay, for time spent practicing or competing over 40 hours. I don't even know what regulating that is going to look like, but I mean, this is going to change the way that the world, if not already, the change of the way that the world of college sports looks like. So I don't know if it's it's better or worse. It's definitely different. And sort of the evolution of the student athlete is like complete. They work for the school. So is Jomar eligible? Maybe. Hard maybe. So in fact, the lawsuit says that they'll pay damages back for dating back to 2016, which was the spring of my senior year. So again, maybe there's a check in there for me. So we'll see. I won't hold my breath though. And then so back to amateurism, right? So this was like, the safe haven, the place that we could, hang out, but in fact, and feel safe. But in fact, I don't know if we have much of that anymore. And maybe we actually were seeing, artificially big fish in this pond, right? Created by the NIL. And I think that now we have this sort of hodgepodge of athletes in competing in college and even in high school that are neither pros, right? So they don't have all the formal things that you expect with professional athletes, but they're not really, kind of the average amateur patient. They're somewhere in between, and we don't yet know how to handle them. And more importantly, we don't yet know what kind of liability they carry, right? The stakeholders are different, and again, they're not the average patient in high school who's just there with their parents, and they're not the pro athlete who has a team behind them and agents that they're somewhere in between. They have these NIL collectives that are depending on their performance, and we're not sure exactly how much we're liable for when we take care of these athletes. And again, this whole idea of being speculative. So this is Quincy Hall, his standout athlete, youngest one to compete in the track and field on the men's side in the Olympics. He has an NIL deal putting his net worth over $1 million now. So if you took care of him and for whatever reason he didn't get back to where his form, he may say, well, that's actually your fault. And I think that that's challenging because he has such a short resume. Right? We don't know what he would have become. We don't know how good he would have been. And so again, this whole idea of this what damages are you truly liable for if someone like this gets hurt? You take care of them and they don't return to play. And again, that's something that the cloud of NIL is bringing on. And finally, right, before we knew the patients who were there to play, and we knew the patients who were there to get paid, and now it's hard to tell, and I think that makes again the landscape for sport team physicians and sports physicians really hairy and challenging to navigate. So closing arguments. So I think one of the things we see, right, it's probably like a lot of risk, right? We talked about some of the good things of going to sport, but it's probably a lot of risk involved, and not only is there a lot of risk, there's a lot of risk hidden from what we do or hidden from us that we may step into and not realize. But no pressure, no diamonds. I think that we so it's a tough field. Being a sports physician in 2024 is challenging, especially if you're going to take care of teams, and especially if you're going to take care of high level athletes or even college level athletes. But we're built for it. And then true amateurism is a scarce commodity now, right? So you really aren't finding just the amateur athlete that you would in college, like myself, who would just go through and be happy to have had it, happy to have had it and remember it, but would never plan to be a pro athlete. Maybe I shouldn't say that before they send me my check, for the damages. And then lastly, and probably most importantly, know the law, right? We went through some of the laws that govern the things that we do, and also important is to do the right thing, do the thing that can, you can make you so you can sleep at night, and do the thing that's going to be right by the athlete and the patient that you're taking care of. Remember, it's, patient first. So. Ooh. Thanks. The references are here.
I don't know if you came across this or how this fits in, but athletes now are teams are taking out insurance policies, if they get injured, is there any sort of, especially like the higher level athletes, is there any sort of liability or change for team positions when that occurs?
Yeah, right. So again, this is just a whole like the same idea of, Jeremy's asking about, what the liability landscape is for team physicians taking care of athletes who have taken out, insurance policies on their NIL deals or their speculated value. And again, this again hits on the point that there's some things we don't yet know. I didn't encounter anything about it. And two, that the landscape is so much different when you're taking care of athletes that they're now behaving more like professional athletes, but in sort of this kind of, hodgepodge of a way. So no, I don't think we've elucidated yet what that means for team physicians taking care of kind of these individuals who have these high value NIL deals and insurance policies on them.
You mentioned
Yeah.
Hey, Jomar.
Yeah.
A really good review. And I think the first time, at least I've ever heard anybody talk about this topic at Grand Round. So great job. The climate has changed so tremendously. I don't do sports teams, but a lot of the guys in our community do. And I think with the way things have changed, I think it's hard to rely on your own personal insurance policy. Most of us have limits of 1 million per case and 3 million in global and
Right.
a certain amount. And some of these rewards are crazy money that you could, although most stocks win the case, you could be liable for. And so I think in today's climate, anybody that does sports medicine is basically employed, even if they get no money, they're working for the school, should have a side contract that covers them for anything over their limits. And anyone that doesn't do that, whether it's pro, college, or wherever, is putting themselves at a huge risk. And I mean, you obviously pointed this out on that huge case that settled where a doctor could be liable. And from a doctor point of view, anybody that does it really should explore that avenue.
Yeah, for sure. There's a lot of talk about, and when I talked with some of the sports physician about, the attempts to have the various leagues start covering the malpractice insurance, and so far they've been very shy on the idea because, and I mean, they're not suited. They know like kind of the risk that they would be taking on, and again, kind of ballooned up because of this idea of social inflation and the expectation of these huge verdicts in these cases. So yeah, no.
Yeah, but the verdict, you're only concerned about when the doctor is found guilty, even if he did everything right. The case about Tua, you can tell him not to play and he can play. The doctor has no liability as long as it's documented. If they explain the risk. It's the case where you did the ACL, something didn't go right, and now it's $100 million. If you're working for the school and helping out, your liability shouldn't be more than what your limits are on your standard malpractice. And that's where I think the school or the institution has to come in, because otherwise doctor that does this is opening themselves wide. They're wide open to a major risk. Yeah.
Yeah, I mean, yeah, agreed. Dr. Gadd, have you made any changes in your saying no, hasn't any changes given the recent changes in the landscape and the climate? Hasn't scared you at all?
I've thought about it, but I haven't made the change.
Gotcha. Yeah, I mean, it's a lot to do. Right.
I don't think a lot of people have taken out an extra policy yet. I think just kind of, it's something that's in the back of everybody's mind.
Yeah.
So like you said, the question is, does the school or the league, does it then provide, extra coverage, on their dime rather than your dime? Because truthfully, not too many top, big time college positions aren't getting paid. They're not getting paid if they take care of it.
Right.
Some of them are like, you know, they're at Ohio State, you know, they're full-time faculty, they're paid by Ohio State University.
Right.
But here, we're not the, you know, Rutgers isn't the only one where the team position is volunteer faculty.
Right.
In Indiana, they're not part of the University of Indiana, there's several teams in the Big Ten where that's the situation. So they're outside the university and outside of all the protections that the university brings. Now, that's another kind of challenging part of it. The ones who were probably employed by the university probably have some protections through the university. Or they're full-time faculty, but I think the people that are not full-time faculty are taking a higher risk.
And I mean, so now that the athletes are employees, you know, how do you think that's going to change in terms of, are they going to have to employ all the physicians now, or they're going to start keep independent contracting? You know, maybe a much different world in the next 2 or 3 years for physicians coming into it, and physicians who have been a part of it for a long time. Yeah, this one was really shocking to me.
Like I said, you know, when you think of pro football or any pro sports, technically it's a workers' comp injury, right? They get hurt on the job. And in the past, college athletics was not that, but now they're moving in that direction where this becomes work comp.
Yeah. Very interesting stuff. You can
To Jeremy's point, even back in the mid-90s, football players had Lloyd's of London policies on their bodies. So I saw it firsthand, you know, a player who had a terrible injury, ACL and patella tendon. And I got to go into the room with the doctor who was taking care of the Browns at the time. And again, this is, you know, he kind of explained it to me all the way back in the mid-90s, said, you know, this is work comp. The guy looked up at him and said, look, if this is a career-ending injury, let me know. I've got a Lloyd's of London policy on my knee and I'm set for life. If you tell me that I can't play anymore, I want to play. Yeah. But if I can't play, I'm not going to cash out.
act accordingly.
That was 1994. Wow.
You hear a lot about it now. I don't know how many of them actually get put out, but yeah,
But there are high school kids who are getting NIL money. So that, you know, we talk about, you know, think of NIL as a big time university, number one, even small universities have NIL. But there are kids who have been kind of identified as future stars and they're getting NIL money. And now they, you know, you can talk about their lost earnings and things like that.
Right.
You don't know that they're gonna be, it doesn't matter. They were getting NIL money, they were getting NIL, guaranteed NIL money in college and it's gone. So there's a whole future earnings thing, I think has really thrown a monkey wrench into everyone's idea of just doing the right thing.
Yeah.
Especially with the Marigo settlement. I mean, he was a special teamer, like got so much money.
Yeah.
It's insane.
Yeah, and in fact, he only sued for like 8 million, and they doubled, tripled, quadrupled down on him and said, "Oh, take all this in as well." Yeah. So
yeah, that one is super frustrating from like a watching sports standpoint, because the judge in that case said, "How do you quantify someone not being able to realize their dreams because of an error that was made surgically?" And are you kidding me? I mean, that guy was undrafted. He's the captain of the team. He's gone to the Super Bowl. If he hasn't realized his dreams, then no one has. And yet he's the end of his career. His days are numbered anyway. And now he gets whatever he got, $40 million. And he, you know, now they don't have a team position there. So that is so skewed. It's nauseating. But that just shows you where the lay public, who doesn't even understand sports careers, can make a big decision.
right.
So Ryan here again. You mentioned earlier in your talk that HIPAA doesn't really cover
Employee.
Players team.
Right.
Does HIPAA protect against the dissemination of players' private information to other teams and legal audit? If they are actually
No, and in fact, they're like, like injury, like roster. You have to like put, what injuries people have. So no, because again, it's all a part of the employment record. So it's like being healthy and able is a part of like your job description. And so you have to report that to your job. And if you're not, then your job knows, and they can, in the league, whether the way the leagues, the various leagues, the way the rules are written, they can do with that as they please, sort of. So
From federal attendings. So after if you do get sued and it goes over that cap, what do you do to mitigate your own risk from them coming after you personally? Or how do you, I guess, mitigate that, to protect yourself?
Yep.
I mean, I think I don't know what happened to the guys at Rockland, but Rockland picked up a lot of the extra money. It probably depends on your employment agreement. So it could be that your practice picks it up, or depending on your employment agreement, you could be individually responsible for it.
Could include that.
If you're hired through through an LLC, then you personally are protected, right? It's just the business itself that would go right liable.
I mean, I've heard of surgeons giving trust funds and then basically removing the name off a lot of their stuff too, as far as.
That pertains to all malpractice. I mean, obviously, you look at these cases, but they're, they could be, surgeons who have lost massive cases on just the average Joe on the street.
Yeah.
They're in the same situation. So, there are people who tell you all about ways to protect all
assets.
your wealth, so that it's not in your name. So that if you ever lose something outside the boundaries of what your insurance covers and maybe what your practice has, that no one can have, that it's not in your name. And a lot of advisors will be happy to talk about it. It's, something to think about.
Joe, I had a question. I have a question. So, like, for example, as a sports doctor, we learn a lot about orthopedics.
Thank you.
But we don't necessarily learn a lot about like neurology and things that maybe involve, say, the severe injury, like
Sure.
concussion or two of them. So how does that work when you're called out to the field? Are you then tasked with, say, treating a concussion, and if something were to be called into question, how does that work then, since your board certification would be through, say, orthopedic surgery and not through neurology?
Sure. So one, it depends on the resources that are available to you at whatever institution or game. So like, right, when we're covering the high school games, right, it's just us. But when we're at, those, at the Rutgers football game, like it's there's an ortho attending, there's a family sports medicine attending, there's 2 fellows and resident. So there are a lot more individuals around, and that just, it varies on the resources. As far as what you're allowed to make a judgment, I mean, that falls within the purview of just doctors. So and again, the whole idea of what's required of a sports physician, kind of sports specific knowledge, that falls under that, your purview. You should be, you got to know. You gotta know how to treat athletic injuries, common athletic injuries, and that's one of them, even though it's not musculoskeletal. Okay, Sean. We'll have Sean join us up here. Thank you. Thank you so much, everyone.
Can you hear me?
Yep.
Jomar, hey. Yeah, so thinking about the Maragos case, from what I've read, it often comes down to the usual stuff, which is documentation, communication, and doing the right thing for the patient. You do have to document this stuff. They had a problem with documentation and duplicative records or changing of the medical record. You can never do those things. That loses your case for you. But you have to document, and so when good record keeping has to be part of your training room. However you're going to do it. You see someone in the training room, you're making decisions. You ought to be documenting that sort of thing.
Yeah. Yeah, agreed. And again, the whole idea of casually covering sports games now is put on its head with random athletes who have these NIL deals and have these, huge liabilities attached to them. Now your documentation, is changing on the fly, whereas before you may, note things in your head. Now when a lot can go wrong, and a lot of it can get really legal really fast. You have to be more on top of documenting in cases where you otherwise, may have been more